Thank you for joining us for another episode of Baker Hosts Ad Nauseam, a podcast series focusing on new and trending advertising issues with an emphasis on the FTC and the NAD. I'm Randall Rubin King, and you're listening to Baker Hosts. We are once again joined by Amy Mudge and Daniel Kaufman, two partners from BakerHostetler's advertising, marketing, and digital media team. Together, they have decades of advertising experience and approach advertising issues from multiple perspectives. On today's episode of Ad Nauseam, Amy and Daniel are back to discuss consumer perception surveys, a tool that businesses use to gauge how consumers view and interpret advertisements in part one of their new series, Survey Says, the Consumer Perception Study. With that, welcome to Ad Nauseam, and let's turn it over to Amy and Daniel.
Welcome, and thank you for joining us once again for Ad Nauseam. Today, Daniel and I are going to begin what will be a multi-part series. We have not decided how many parts, but it will have several parts on consumer perception surveys. Today, we're going to talk about why one might want to do such a survey, and of course, when you have to do such a survey, and we might start riffing on some of our classic favorite surveys. But when I hear survey, I can't help but think of Family Feud. Now, I'm talking the original Family Feud with Richard Dawson, where he would ask each family for an answer before pointing to the board and saying, "Survey says," before revealing an answer. So, got me thinking, Daniel, I gotta ask, what are your favorite game shows?
This is an awesome question that brings me just more joy than it should. Childhood memories of being home allegedly sick, watching The Price is Right with Bob Barker. That is key to me. And actually, my TikTok feed right now has been showing me old clips from The Price is Right with cars costing $6,000 or $7,000. It was the best. I adored Let's Make a Deal. I always wondered, why did these people have a hard-boiled egg in their bag? Just all of this stuff. But finally, I got to add just props to, it was only on for a couple of years, but the $1.98 beauty show from the late 70s that I enjoyed a lot.
Okay, I don't know that one, but you had me at Rip Taylor. And Price is Right. Yeah, I have, when I would stay home sick from school, I just couldn't wait to get all of the soap operas, every single one. I had no idea what was happening on the ones at noon, but they were easy to catch up on. But when I'd visit my grandparents, yeah, the Price is Right. But I have to say, the Drew Carey one's pretty good. In general, I'm not a fan of the updated hosts. I like those originals. I think Drew Carey's killing it. I will say jury's still out on whether Ryan Seacrest can pick up on Wheel of Fortune, but I like the sort of scandalous, the naughty 70s game shows, like the Newlywed Game. That was always just a little bit edgy, the Dating Game. I think those were where I'd go. But my mom, every night, she watches Wheel of Fortune, she watches Jeopardy, she never misses a night. So I have to say, when we're with her, we are still glued to the TV. Now I think it's from 7 to 8, but we're always there.
Yeah, well, I got to say, Amy, I would say a big no to Ryan Seacrest on Wheel of Fortune. I just don't approve, but I actually think Steve Harvey is great on Family Feud. I actually really do enjoy what he's doing there.
I don't actually think I've ever seen him. I think I've only seen the SNL knockoff skits of him. So I'm not really sure if I know how he does it or not. But all right, survey says, let's get back to it.
Yes, and today, hopefully, we're going to have all the answers about when, about why an advertiser might want to conduct a consumer perception study. And, we're not talking about the kind of focus groups here or research done routinely for marketing purposes. We are talking the litigation quality survey that are used to copy test an ad or a product label in order to understand if consumers understand the intended and supported message of an ad, or if we've got a meaningful number of consumers taking away some sort of false or misleading message.
Indeed. And, look, well, a few quick basics. An ad obviously can have express claims, or what the literal words promise, but also those pesky implied claims, or what an ad can reasonably be understood to promise. So, for example, this is a classic one. You will lose 5 pounds a week is an express promise. Showing a testimonial where a user talks about his experience and says, I lost 10 pounds a week, to imply or promise that others will have a similar experience and will also lose 10 pounds a week. And one of the things that's vexing to advertisers is an ad can have multiple reasonable messages, and an advertiser is responsible for substantiating all of them, even the ones that they didn't intend. So, what messages consumers actually do take away from ads is really important at the outset to nail down. This is an issue in an FTC investigation, in an NAD case, in a Lanham Act case, or in a class action looking at whether advertising is deceptive or misleading. And all of these various form, they're different burdens of proof, depending on where you are. But in all of these types of cases, sometimes parties assert how consumers will understand their ads. But other times you pull in the big guns and you do a consumer perception survey showing consumers your ad or your label and asking them questions about what they understand is being promised. We'll talk soon in a future episode about some of the do's and don'ts with survey design and survey analysis. But yeah, today we're going to walk through walking when you might do a survey. And Daniel, the FTC is viewed as a specialized agency that can look at ads and discern likely consumer confusion based on their experience. But the FTC itself will sometimes conduct its own surveys. Can you talk to us about when the FTC might undertake such work?
The short answer is not as often as people might think. I mean, these surveys, of course, are significant resources, are not cheap, and they're not cheap for the FTC either. So the big picture answer is not that often. However, it's important to keep in mind in enforcement cases, the FTC does not need to rely on surveys to show how consumers understand an ad. And we've got a case from the 1990s involving Kraft singles in the Seventh Circuit. The court confirmed that, quote, the Commission may rely on its own reasoned analysis to determine what claims, including implied ones, are conveyed in a challenged advertisement, so long as those claims are reasonably clear from the face of the advertisement. So the FTC will rely on extrinsic evidence, but this may come in the form of experts, it may come from an advertiser's internal documents, including consumer complaints. So the FTC isn't required to submit consumer perception studies in litigated cases, but they will on occasion if the claims are more subtle. Also, less well remembered from the Kraft decision was the Seventh Circuit admonition that the use of surveys should be the rule and not the exception, and that the Commission should adopt a consistent position on survey methodology to help avoid disputes over survey reliability. I haven't really seen the FTC do that, but look, outside the context of litigated cases, the FTC did a survey in a series of cases involving savings claims if you replace your windows, like save up to 20% on your heating bills. And the FTC did a survey purporting to show that consumers did not understand this as promising a maximum benefit or a best case scenario, but that instead they viewed this as the savings they could expect. And to be clear, this caused some furor in the industry, and the FTC actually then made its survey work public. Though I do think it's worth noting a recent statement a couple months ago from Chair Ferguson. He raised his own concerns about the survey.
Oh, with the up to case, right? Where he said, "Come on, up to is up to." I love that. I love a chair saying, forget about the study." But there were, there were a lot of criticisms levied at that study. And again, we'll talk about some of the ways you do critique a study in a future episode. I'm actually, Daniel, the FTC has experts on staff. It has a whole Bureau of Economics full of economists. Has the FTC ever had survey experts on staff, or that's something that they always will third party out, so they've got to have the resources to do it?
So there have been marketing experts that have sort of formal affiliations and agreements with the agency sort of on a part-time basis, but certainly they've never had like a full-time, that I'm aware of, a full-time sort of survey person, but they definitely have marketing people they work closely with on these things.
And, where I think you see the FTC doing surveys with some frequency is in connection with drafting or updating business guidance. And so, for example, moving ahead 20 odd years to the 90s, yes, the FTC was looking at Made in USA, and it decided to survey consumers to see if they understood that a Made in USA claim referred to manufacturing processes or whether consumers took away a broader message that manufacturing and ingredients or components were of domestic origins. And the results were of a pretty mixed bag. But the FTC went with its all or virtually all of the cost of the product should be attributable to U.S. sources standard anyway. Now, when it updated its green guides in 2012, gave a little bit more credence to some of the survey work it did. It did a survey of how consumers understand, at the time, sustainability claims. All right. And at that time, sustainability claims weren't as ubiquitous as they are today. And the FTC wanted to understand, do people take away a green message from such claims? If so, what message? But what they heard in this study is a number of consumers saying they thought when they heard sustainability, that meant durability. All right. And that didn't, connect at all to a green promise. And so based on this, the FTC actually decided not to give specific guidance on how to use such claims in the green guides context. Probably will change with the update we're expecting any day now.
Any day now, absolutely. Yeah, no, sometimes you sort of see the results and you just sort of scratch your head and you're like, what were they thinking? But also, like in 2009, when the FTC updated, in connection with the updates to the testimonial and endorsement guides, the FTC surveyed the use of results not typical disclaimers in advertising, which of course we saw for decades. That survey showed consumers did not understand that when an ad had a testimonial that claimed weight loss of 20 pounds, that this might not be something that was readily attainable. And based on this, the FTC said a results not typical disclaimer should not be used. And instead, if a testimonial showed an atypical result, the advertiser would need to disclose what results are actually typical. Quite a big deal. But Amy, in a Lanham Act context, surveys are often required, right?
And so, if a company's bringing an action alleging that a competitor's advertising is literally false, then you don't need a survey. But in the more typical case where an allegation is based on an implied claim, yes, typically the plaintiff or challenger will have the burden of establishing that consumers are taking away a false message. There's a little nuance. Unless the claim is so obvious that it would be implied, that's something called false by necessary implication. That's a whole other podcast episode. But generally, if in a Lanham Act context, if there's an implied claim at issue, a survey is needed off the bat to support the complaint and a typical request for a TRO or preliminary injunction.
Yeah, it's funny, Amy. Just remind me. I remember a case I was litigating many years ago, and I was at the agency. I kept on referring to the claim we were challenging as virtually express. It was so close to express that it was virtually express, but the words we were sort of alleging as the claim were just a little bit different, and we got away with it.
Daniel, you are okay. All right. That's marketing copy at its finest. I have to say, virtually express is so much better than false by necessary implication. That should have been picked up. I gotta say.
Yeah. So, but okay, let's turn to NAD. So, challengers will often ask the NAD to review certain claims, both express and implied, in a competitor's ads. So, challengers sometimes submit surveys, but don't have to. NAD will, of course, use its expertise and step into the shoes of the consumer and decide what claims can be reasonably implied from an ad. So, Amy, if neither party in an NAD case needs a survey, when and why would a party decide to go to the expense to do one?
Well, sometimes when what an ad implies is pretty facially clear and the challenge will be comfortable that NAD will agree that that implied claim is being made, they won't go to the time or trouble. Now, other times, sometimes challengers stretch and an advertiser, well, sometimes a challenger might, feel it wants a survey to back it up. But if a challenger's asserting something that the advertiser feels kind of out there, but is a little bit worried what happens when NAD will step into those shoes, the advertiser might feel that it really needs evidence to back up that an implied message a challenger says is there is really not a message that's being taken away. So, again, this ads can have more than one message, and they definitely can and do say different things to different consumers. In a survey, typically you need to show evidence that approximately 20% of consumers took away a false implied message. Now, in some litigated context and at the FTC, sometimes a lower number has been found to be sufficient. But certainly, if 20% of respondents take away a message that cannot be supported, an ad will often be found to be misleading.
Yeah, and I always think 20% is a pretty low number. And we know there's just a lot of folks simply confused a lot of the time. So it's always felt like a very low bar to me. But, of course, advertisers are not going to be responsible for pre existing beliefs. And there are going to be efforts made to set aside those people who are just not paying attention. This is often done by using a control.
And one of our future episodes will talk lots about controls because that really is the art and the science in surveys. But look, you ask consumers in a survey what they understand to be the main message from an ad. And then you ask increasingly targeted questions designed to ferret out if they find a misleading message that you believe is there. But you also do typically need to create a control or a version of the ad with that part of the ad that you believe is causing the deception and remove it. All right. So, and then you ask the same questions using this cleaned up version of the ad. And if any consumers are still confused by the new and improved ad, you subtract that level of confusion to get what's called net deception.
And maybe an example would be helpful here. So let's go back to the results not typical example. There's a weight loss testimonial ad where a person says they lost 50 pounds drinking Fat Away shakes, because the names are always really subtle. And there was a really small results not typical disclaimer. So a survey of those who had or would likely in the near future purchase weight loss products would be shown that ad and asked what the main message was. And then they might be asked if they thought the ad promised weight loss, and if so, what's the amount? So let's say 30% of the people said they thought the ad promised they could lose 50 pounds using Fat Away. And then a control ad would be created. The same ad, but that said in the headline that most people lose 10 pounds or 1 to 2 pounds a week using Fat Away. And the same questions would be asked. So let's say 10% of people said they thought this ad promised they would lose 50 pounds. You would subtract the control results from the test ad results for a net confusion of 20%, which is likely still enough to show the original ad implied a misleading or unsupported message.
Now, we're not going to get into the fine details today, but let's talk a little bit about the mechanics here and what you said in the beginning, how those surveys differ from marketing surveys. And one thing is who conducts them. Typically an academic or at least someone with a marketing degree and background in surveying consumers will be hired to draft a litigation quality survey and analyze the results. And typically they will work with a third party who is set up with a consumer panel to actually field the survey. This is not something that can be done quickly in-house. In the old days, often those surveys happened in one of Daniel and my favorite places, in a mall. Now, with rare exception, those surveys are conducted online.
Yeah, and in marketing surveys, even if perception questions are asked, often the main thing being looked at is purchase intent. Will the ads motivate a consumer to buy the product? And there will often be background information provided about the product. In a consumer perception survey, that could be said to bias the results if you tell participants up front what you're selling and its attributes.
Yeah, there are lots of ways a survey can be critiqued for introducing bias, including how the questions are worded. And the design of a survey to limit the critique of bias is really key. And it's another area where survey design is really art and science. Now, Daniel, I want to go back to asking about the utility of surveys in an FTC investigation. Is it common for companies under investigation for false advertising to submit surveys? And are they persuasive for staff?
I mean, I would say, Amy, they're somewhere between uncommon and common. You see them once in a while, but you don't see them routinely. And it really depends upon the nature of what the FTC is investigating. Very often, they really are looking at express claims. And you're very unlikely to come forward with a study that says, obviously, the express claims don't say what they say. So, but when you have the FTC looking at sort of more subtle issues, potentially implied claims, I would say it's not uncommon for a company to come back preliminary information or preliminary data showing that there are, some copy test results that are bringing questions about the FTC's interpretation. So I do think it is a really important tool to think about based upon the nature of the FTC's investigation.
Yeah, and in Lanham Act cases, when they're litigated, it's often both sides have a survey, and the court needs to dig in and decide which survey is more reliable. I'm hard pressed to think of, well, there's so few FTC litigated cases, in courts or administratively, but I'm hard pressed to think of one where the FTC had its own survey they submitted, and a party and a target had its survey submitted. But yeah, when the cases are private, those are more and more common. And sometimes we have that at NAD too. Sometimes there's no surveys. Sometimes one side will submit a survey and the other side will, typically in that case, at least hire a survey expert to critique the survey. But sometimes there are dueling surveys, and that's hard to do within the time constraint of an NAD action. But another factor that I think at the NAD that parties mull about is, if you submit a survey, that's going to add time to the decision, because not only does the NAD have to decide how a case should be decided, they also have to go through the survey and decide, is the survey reliable? Is the survey not reliable? Why or why not? And if not, then they have to go through that stepping in the shoes of the reasonable consumer exercise. So I think it's funny. I spoke at the last NAD conference, and we on evidence, including survey evidence, and we did a poll of staff to say, hey, do you like it when surveys are submitted? Because that takes some pressure off of you, right, to decide what claims are implied. The FTC staff actually said, no, it's a lot more work when we have to go through surveys, and we kind of know it when we see it ourselves. But, it's my sense that when there are surveys at NAD, it's not uncommon for NAD to find fault with the surveys, so not to credit them as reliable. We'll talk about it next time, but there's a lot of ways to pick at surveys. But that said, it's my sense that even if NAD finds fault with the survey, that NAD can also be kind of swayed by them. At least it sticks in the back of the mind. So, if a case, or particularly part of a case, really matters, we typically at NAD do encourage a party to spend the extra resources and do a survey.
Yeah, Amy, I can remember like an FTC case where the FTC submitted a survey data, but the survey just didn't quite make the point that the FTC wanted to. And the survey instead showed that the claim could have been made more clearly, but that, of course, is not the standard. So really interesting. So do companies often do surveys proactively?
Well, as you pointed out, they do a lot of focus group surveys, right? What's going to motivate you to purchase, and marketers survey consumers all the time. But litigation quality surveys up front, typically not. It's a really, really big investment, and they take some time, and there's often just not a lot of time to do one. And, NAD cases are fast. You need to respond to a complaint in a few weeks. So, having a relationship through your advertising counsel with a quality survey expert, if you need to get the job quickly, if you are in an NAD or a Lanham Act context, is really going to be important.
Yeah. Well, Amy, I think we have set the table on surveys and hopefully gotten our listeners in the mood for more. Because next time we tackle surveys, we're going to welcome back the very popular Randy Shaheen.
Professor Shaheen!
Yes, indeed. And we will explore some of the detail of survey design and analysis. And Survey says that is a wrap on another edition of Ad Nauseam. Thanks for joining us.
Thank you, Amy and Daniel. If you have any questions for Amy or Daniel, their contact information is in the show notes. For more information on the latest developments in ad law, visit our Adventures in Law blog at www.adventures-in-law.com, and check out all Ad Nauseam episodes by subscribing to Baker Hosts wherever you get your podcasts. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.